I'm very happy to call to order. My apologies for a late start. For this, the 60-second meeting of the Standing Committee on Public Safety and National Security, as we begin our consideration of Bill C-23, an act respecting the pre-clearance of persons and goods in Canada and the U.S. Mona Fortier, welcome. What a pleasure to have you. I know you're substituting today, but have you been at a committee meeting before?
Yes, I have.
Oh, and you're a pro.
Committee.
Not this committee.
Not this one.
But on behalf of the whole committee, welcome, and your experience with other committees can only go downhill from here.
We'll see.
Welcome, Minister Goodale and Mr. Bolduc and Ms. Werrett and Ms. Watkinson. Thank you for getting us started on our study. And I turn this over to you, and the committee will have questions. Do we have one presentation or two?
One, I believe, Mr. Chair, and then I'll be here until 4:30 when I have another commitment. But the officials will be here for the second hour to provide further information about C-23. And naturally, I'm very pleased to be back with the committee to discuss this very important topic. Ceci est le système qui.
This is the system that for the past 60 years has allowed travelers in Canadian airports to go through American customs in Canada.
Allows Canadian travelers to get through the process of American customs and immigration while they remain in Canada. It saves travelers from having to wait in long customs lineups once they arrive in the United States. It enables direct flights to U.S. airports that would otherwise not accept domestic travel, or rather accept only domestic travel. And it allows Canadians to complete American border procedures before departure while they're still under the umbrella of Canadian law and the Canadian Constitution. Bref, le pré-contrôle est bon pour les voyageurs.
Pre-clearance is therefore good for travelers, good for businesses, good for tourism, and also good for the Canadian economy as a whole.
Of pre-clearance are currently available to travelers at 8 Canadian airports: Vancouver, Calgary, Edmonton, Winnipeg, Toronto Pearson, Ottawa, Montreal, and Halifax. What we're trying to do is to make these advantages available to more Canadians in more parts of the country, beginning with Jean Lesage Airport in Quebec City, Billy Bishop Airport on Toronto Island, and train routes out of Montreal and BC. We'll also be upgrading the limited operations that now exist at certain cruise ship and ferry terminals along the BC coast into full pre-clearance. We'll be pursuing the pre-clearance of cargo and the implementation for the first time of Canadian pre-clearance operations in the United States for passengers moving in the opposite direction. To get this done, both Canada and the United States must agree to the terms of the expansion. After several years of negotiation, the agreement was finalized in the spring of 2015. It was tabled in Parliament at that time. Legislation to implement it was adopted by the United States last year with unanimous bipartisan support, and it is now up to Canada to enact our own implementing legislation so the expansion of pre-clearance and the benefits that it brings can move forward. We introduced the legislation in June of last year, and it is now, I'm happy to say, before your committee. I know that certain concerns have been raised about Bill C-23, both in the media and in the House at second reading, so I want to take a few moments to address them, and I hope correct any misconceptions that may exist. To begin with, the new framework established by C-23 is generally quite similar to the one that already exists under the pre-clearance arrangement that dates back, the current one, to 1999. Under both the old agreement and the new one, for example, U.S. officers in Canada may question travelers, examine and seize goods, and conduct frisk searches. And under both the new agreement and the old agreement, U.S. officers may detain a traveler if there are reasonable grounds to believe that he or she has committed an offense, with the requirement that the traveler be transferred to Canadian custody as quickly as possible. U.S. officers do not have that power of arrest. Where there are differences between what exists now and Bill C-23, they are relatively minor. For example, under both C-23 and the current framework, U.S. officers may detain a traveler for the purpose of a strip search, and they must request a Canadian officer to conduct that search. The only distinction under the new legislation is that a U.S. officer could conduct the search themselves in the unlikely event that a Canadian counterpart is not available. And there are strict rules around the search procedure. As regards withdrawal from a pre-clearance area, both C-23 and the current framework allow travelers to withdraw. The only difference is that under C-23, a traveler could be asked who they are and why they are leaving the pre-clearance area, in order to prevent people from entering pre-clearance areas in a casual way to probe for security weaknesses and then trying to depart from that area undetected. C-23 is clear that once a traveler has declared their desire to withdraw, an officer may not unreasonably delay them. To understand this provision, I think it's important to keep in mind that the concept of reasonableness is used very widely in Canadian law. For example, Section 8 of the Charter of Rights and Freedoms protects against, quote, unreasonable search and seizure. The Customs Act requires that the search of newly arrived travelers be conducted, quote, within a reasonable time. And the Criminal Code says that a person who is arrested, quote, shall be taken before a justice without unreasonable delay. Generally, courts have understood reasonableness to mean that other people in the same situation would be expected to reach the same conclusion or behave in the same way. With respect to officer authorities, the term has been used to refer to generally accepted standards. In fact, when the existing pre-clearance law was being debated back in 1999, the NDP at that time argued in favor of adding the word reasonable to the section on the use of force as a way of limiting officer authorities. In other words, far from being vague or a license for abuse, the requirement that travelers not be unreasonably delayed imposes a standard that is familiar in law and familiar to the courts. The bottom line is that a traveler who wishes to leave a pre-clearance area will be free to do so after answering a few basic questions about who they are and why they are leaving. Another concern that has been raised both in the House and the media has to do with whether eventual Canadian pre-clearance operations in the United States would complicate boarding in the United States for people who are permanent residents of Canada. The answer, in almost all cases, is quite simply no. Permanent residents would be treated exactly according to the same procedure and in the pre-clearance areas as they would at any other point of entry into Canada. The rare exception would be for a permanent resident with a major issue of inadmissibility, such as serious criminality. Such an individual could still come to Canada, subject to the usual admissibility rules, at an ordinary point of entry, but they may not be able to benefit from pre-clearance because Canadian pre-clearance areas at U.S. locations would not necessarily be equipped to deal with serious criminal cases. I'm also aware of questions as to whether C-23 might limit the use of technologies that help reduce wait times at the border, such as automated passport control kiosks and mobile passport control applications. To be clear, our government is supportive of these technologies, and C-23 does not restrict their use outside of pre-clearance areas. With respect to the authorization to carry weapons, U.S. officers would only be authorized to carry the same weapons and the same restraints as Canadian officers do in the same environment. For instance, because Canadian border officers do not carry firearms when dealing with passengers in airport terminals, neither would American officers. The same rules apply both ways. This is part of the principle of reciprocity in the pre-clearance agreement, which also gives Canadian officers the same authorities in this regard as U.S. officers on American soil. In addition, Bill C-23 maintains that very strict limit on the use of force by pre-clearance officers that currently exists. The pre-clearance agreement also stipulates that pre-clearance in both countries shall be conducted in a manner consistent with both countries' laws and constitutions. And this is really the fundamental point. The expansion of pre-clearance means more Canadians will be able to benefit from charter protections when they are crossing the border. Today, a Canadian flying from Quebec City or taking the train from Vancouver to the United States must subject themselves entirely to American customs and immigration procedures on American soil, with no Canadian legal or constitutional framework. This bill is essential to changing that. So there will be more people at more locations traveling in more modes of transportation that will have the opportunity to pre-clear before they depart. In other words, while they are still on Canadian soil and under the umbrella of Canadian law. I'll conclude on one final matter. At second reading, the New Democrats moved an amendment to reject this bill, notably on the grounds of what the amendment called, quote, the climate of uncertainty at the border, end of quote. So let's be clear. Some 400,000 people cross that border on a daily basis, almost entirely without incident. And statistics, interestingly enough, show that fewer Canadians, not more, fewer Canadians are being denied entry to the United States this year compared to last year. Nevertheless, I have met with the Secretary of Homeland Security and underscored my expectation, and I think the expectation of all Canadians, that travelers headed in either direction should be treated fairly, respectfully, predictably, consistently, and in accordance with law. In fact, it is precisely with legislation like Bill C-23 that we can best reduce uncertainty for travelers by establishing a clear legal framework that requires U.S. officers to adhere to Canadian standards when they're applying Canadian law. Not just in the 8 locations where pre-clearance currently exists, but at many sites and in as many modes of travel as possible. Ultimately, the expansion of pre-clearance will make travel and shipping, hopefully, to and from the United States faster and more efficient. It will provide significant benefits to the Canadian economy, and it will enhance the protection of travelers' rights and freedoms. And it will only happen once we pass this bill. Thank you, Mr. Chair.
Thank you. Ministre, on commence avec le premier tour.
Thank you. We'll start with Mr. Picard for the first turn with 7 minutes. Thank you. Hello. Thank you for being here. Former colleagues from our previous life, welcome. When talking about customs, most Canadians see the security aspect. We just came from a trip to Washington where we met with a number of elected officials, and most representatives of the Congress told us, to our great surprise, that they had practically no problems with Canadian customs. the security component seemed less significant, and they told us that the economic and commercial component of the pre-clearance agenda was the most significant component with the largest impact. Minister, could you tell us what the economic advantages would be of this kind of agreement? And with increased pre-clearance measures, what we can expect as improvements from the trade perspective and the economic perspective?
Thank you very much, Mr. Picard. The border between Canada and the United States is a remarkable institution. It's not without controversy sometimes or difficulties, and we should always work very hard to reduce those controversies and difficulties and make the border work even better. As I mentioned in my remarks, there are 400,000 people that go back and forth across that border every single day. Every day, 400,000 people. In addition to that, there's $2.5 billion in trade, two-way trade, that goes back and forth across that border every single day. That is a huge and valuable relationship. It is, I think it's fair to say, the longest unmilitarized, most successful boundary line in the history of the world. And it works for Canada. It works for the United States. It needs to be safe and secure. It also needs to be efficient and expeditious. Pre-clearance is one of the tools by which we can accomplish all of those objectives: safe, secure, efficient, and expeditious. We have it at 8 airports at the moment, so air travel moving south into the United States. What this agreement and this legislation seeks to achieve is to make it available in all modes of transportation, not just air, and make it available at a great many more venues and locations across the country, and to make it available in both directions. And while our focus has always been on the passenger travel, I think you're touching on one of the great potentials here, and that is the expansion of pre-clearance to include cargo, where instead of waiting in some of those long lineups with the big trucks trying to get across the bridges into the United States, and there's a lineup at the clearance point, you could actually envisage a situation where the goods are loaded onto the truck at the plant or the factory. The truck is inspected at that point and sealed, and then once it has pre-cleared at the factory, it can just go across the border without any further examination. Now, it will take some time to develop that kind of a system, but the agreement and this legislation contemplates that, enhancing the cross-border trade. And I'm very pleased to have heard Secretary Kelly, in his appearance before a congressional committee a few weeks ago, saying that he thought the Canadian border was a good example of a situation that was working properly, and he wanted to see that border become thinner, not thicker. And he had some very complimentary words about Canada and Canadians and the border service operation and so forth. That's a positive thing. I wouldn't want to leave the impression that pre-clearance and cargo can be achieved simply. It's a big project to undertake, but the legislation and the agreement behind it allow for that eventuality to come about.
We did discuss about cargo with our colleagues in the U.S., and we understand that on their side, they do have a number of additional steps to go through, considering that they have to obtain the agreement or approval of a number of organizations. Can you give us an idea of how things will happen after this bill goes through, if it does? What are the steps following the implementation of pre-clearance, U.S. and Canada, Canada in the U.S., and maybe what are the challenges to get cargo along?
Well, they're significant. We shouldn't pretend that this can be done without a good deal of negotiation and hard work, and perhaps some further regulatory and legislative measures, especially in the United States. But what I'm pleased about is the very clear statement by both the Prime Minister of Canada and the President of the United States when they met at the White House a few weeks ago, saying that this is a priority for both countries and they intend to get it done. It wasn't just a statement of objective or hope or ambition. The two leaders committed themselves to getting this work done. There have been some pilot projects that have been tested out to identify the kinds of issues that would have to be dealt with. So there is some work underway, but more needs to be done. And I think with the enthusiastic support of business leaders and exporters on both sides of the border, we can keep the momentum building toward a practical, effective solution.
How much time do I have, Chair?
Vous avez juste presque 20.
You have nearly 20 seconds.
Thank you, Dan. Thank you.
Mr. Clement.
Thank you, Minister, for making an appearance here. I think that's very important as we discuss this bill. You may not be aware, but several weeks ago I had the occasion to be in London, UK, with David McGuinty at a Commonwealth Interparliamentary Conference on national security and cybersecurity. And one of the themes that was common throughout all of the jurisdictions that were represented there was the need that, the idea that in order for security measures to work, it was important that the population buy in to those measures. You've really got to have that public support because we're asking a great deal when it comes to security measures and the, in some cases, extraordinary aspects of that. Now, you did address this in your remarks, but I do want to return to it a little bit because the primary concern that seems to have emanated from this bill has been the issue about U.S. officials detaining Canadians on Canadian soil. So I'm just giving you the floor to address those concerns. I know you did a little bit in your remarks, but I think that seems to be one of the issues that has gained some traction within the public mind.
Well, it's an important issue, Mr. Clement, as you point out, for security and safety procedures to be respected and effective. The public has to have confidence that they are properly framed and properly applied. That's why the agreement and the legislation go to some length to lay out the rules and procedures so that it is clear in the law. That's one of the questions I remember first asking my officials when they presented me with the draft legislation. The question, do you really need all of this excruciating detail in the bill? And their answer was yes, because when you lay it out and specify it according to the terms of the agreement with the United States, then you've really built the fence and nailed down the parameters of conduct. The core point is that when American officers on Canadian soil are applying the law, they have to do so, and the bill is very clear in this respect. They have to do so in a manner that is consistent with all Canadian laws, including the Bill of Rights, including the Charter of Rights and Freedoms, and including the Canadian Human Rights Act. All of those are applicable. And that is a clear distinction to what would be applicable if you did not have preclearance and you were simply doing the normal custom clearance in the United States on U.S. soil, because it's then their framework. that applies as opposed to ours.
So I guess one of the things that that you may be contemplating is upon should this bill be adopted by Parliament, that there might be a need to have some public communications on this to stress this point. Is that reasonable?
Yes, and training, Mr. Clement. As there is already training under the existing pre-clearance arrangement that goes back to 1999, but those American officers that would be functioning in Canada would be trained.
Trained by Americans or by Canadians?
By Canadians, by CBSA,
right.
And others who would make it clear to them what the rules and provisions are of the Charter of Rights, of the Bill of Rights, of the Human Rights Act. Those are that creates the framework within which they function, and they need to understand the terms of those fundamental laws, as well as the critical ways in which those laws may be different from the experience that they may be used to in the United States.
Can I just ask? I don't know how much time I have left, Chair.
1.5 minutes.
So, sorry, Minister, but I've got to keep rolling along here.
Go ahead.
With respect to the marijuana legislation that the Government of Canada is pursuing, there has been also some concerns that because in the U.S. jurisdiction that there's still a moral turpitude aspect to marijuana usage or marijuana conviction, that this will still have an issue for Canadian travelers. Do you have any perspective on this issue?
The American situation is complicated because, of course, the federal law in the U.S. Holds the view. The federal government in the U.S. holds the view that that marijuana is and should be illegal, whereas a number of states have in fact legalized it, and several more had referenda at the time of the election last fall, where they indicated that too is the direction in which they intend to go. So the American situation is complex. But border arrangements are under federal jurisdiction, and it is the federal view in the U.S. that would prevail at the border. What people should appreciate, though, is that importing and exporting cannabis today is illegal, and it will remain illegal under the new regime. So in that sense, crossing the border with marijuana is an offense now, and it would remain an offense in the future. Mr. Clement, just to finish the point you were raising earlier, I would invite members to look specifically in the law at Section 10, subsection 2, and Section 11, which articulate very clearly the legal frame that applies to officer conduct.
Thank you.
Oui, merci. La prochaine sera M.
Thank you, Mr. Dubé. Thank you, Mr. Chair. Thank you, Minister, for being here with us today. To respond to the comment regarding our amendment, I would say that the statistics regarding the number of people who are turned away at the border are of no consolation to those who are discriminated against because of the color of their skin or other. And there is a situation that is very problematic that exists. Now, coming back to the bill, we've talked a lot about limiting the expansion of powers for officers regarding those who are in the pre-clearance area. I'd like to draw your attention to Section 33(1) regarding the information that is retained regarding travelers once they exit the pre-clearance area. And we're talking about legitimate authority, and that's problematic because I'll give you a hypothetical situation. I know we don't like them in politics, but it's important to illustrate our point. If there was a decree from the American president stating, like he said in the past, that they're going to look through all the electronic documents, or rather the electronic devices of travelers. I mean, the law in Canada is quite unclear regarding passwords and the provision of passwords when asked. So, and there was a decision in the courts recently that gave more importance rather to the safety than to the privacy of citizens. So that's why people believe that we will be some of our rights under the Charter will be set aside under this agreement. And does this law give the authorities power to request that, especially for people who decide to withdraw from a clearance area?
Mr. Dubé, first of all, I would make this point. If there are refinements in the terms of the law that the committee feels are appropriate, I hope members will bring those recommendations to my attention. As I said in the debate in the House, I'm anxious to consider constructive ideas for improving the law. The constraint that we have, of course, is the international agreement that already exists, and the legislation needs to be consistent with that agreement. But if there are ideas where greater clarity is required, certainly bring those issues to my attention, and we'll take a very serious look at whether they could be acceptable. Can I just also make this point with respect to the departure from a withdrawal area? The behavior of the officer needs to be reasonable. Again, that's why that word is there. If there's a pattern of behavior that develops, and I've had this conversation with Secretary Kelly, if there's a pattern of behavior that develops that we find untoward, we have no reason to believe that would happen, but if it does happen, then we obviously have the recourse of raising these sorts of concerns.
You'll allow me to
US
interrupt
government.
you just because my time is limited. So if we go back to 33.1, if we're looking at it, it says, except for the purpose of maintaining the security of or control over the border between Canada and the U.S. or as otherwise authorized by law. So in that situation, who's deciding whether to share that information? If someone decides to leave the pre-clearance zone because they don't like the way they're being treated, I read that section and I see a situation where if any information is available on that person and the U.S. agent deems that it's suspicious, then that information gets sent back to the U.S. government because it says, except for the purpose of maintaining the security of or control over the border. And they might deem that that is exactly the case, even if we would not.
Well, let me ask Jill Warapp to respond.
Certainly. As laid out in the legislation and the agreement, officers are limited. They can ask the person for their identity and their reasons for withdrawing. In terms of the circumstances for the purposes of maintaining security of the border, some examples might be if during the course of questioning a traveler provides false identity documents, for example, and upon withdrawal, the officer determined that this traveler was border probing as an attempt to find weaknesses that could be leveraged to carry out terrorist incident, something like that. Those biometrics captured prior to the request withdrawal could be used in order to identify the traveler. So that's the reason for that type of wording in terms of maintaining security of the border.
Minister, if I may, I just want to, because I think I'm running low on time. Thank you. I want to go to the question of firearms, because we've talked a lot about MOUs, but the memorandums of understanding, but those actually, as far as I understand, don't actually have any legal power. And when we look at the text of the bill itself, what is preventing in a designated zone by a designated agent or U.S. agent from bearing a firearm? Because you've mentioned reciprocity and the MOUs and so forth, but there's no legal power there that can be enforced, is there?
There is nothing either by the agreement or the legislation. There is no power or authority or right or privilege conferred on an officer of one country that is not equally conferred on the officer of the other country.
Sure, I understand that. But if we take Pearson Airport, you've said that the principles of reciprocity being what they are, CBSA doesn't bear arms in Pearson because the police ensure
or any other airport when they're dealing with passengers.
What in the bill prevents an American agent in the appropriate designated zone from bearing their arms?
Canadian law.
But the exemption to the criminal code is in this bill. They're allowed in the designated zone to.
If I may,
I'll ask Martin too.
CBP officers would operate under CBSA policy. So carriage, storage, and transport of firearms would be aligned with CBSA policy. So they would not be able to do something with a sidearm that CBSA is not allowed to do.
And is that explicitly stated somewhere, or does that require regulatory change?
It's clearly stipulated in an agreement we have with US CBP that.
Does that agreement have force of law?
I'll examine the question, Mr. Dubé. My view is yes, it does, and these are the rules. These people will be operating on Canadian soil, and they'll operate according to the rules that are specified in the agreement and in the legislation. If it needs greater clarity, I'm happy to make sure we provide it. And the point about this arrangement being better than the alternative, I think is an important point to bear in mind. If we did not have the agreement and the legislation, then all of the rules would be written in and for the United States, because the whole process would take place in the United States on Canadian soil according to their framework, with no international agreement and no Bill C-23, and that would leave Canadians more vulnerable.
Thank you, Mr. Minister. I'm just going to suggest that if either the minister or officials think there's a document that would help answer that question, or if Mr. Dubé knows of a document that could be helpful, it would probably would be helpful to the committee.
Happy to provide it, Mr. Chair.
We're going to continue with Mr. Spangeman for 7 minutes.
Thank you, Mr. Chair. Mr. Goodale, it's great to see you. Welcome back. And a warm welcome to senior departmental staff as well. Minister, on previous occasions, you've characterized the task at hand for the field of public safety, for this committee and for your work, as not trading off rights versus security, but the need to do both, to be good on security and to fully protect Canadians' rights, including charter rights. And in this case, there's a third spoke in the wheel, which is trade and the movement of people. So it's about business, it's about tourism, it's about family relationships across the border. And in my own reading, I discovered that the cross-border relationship in terms of pre-clearance takes us back to 1952, some 67 years, not all with an agreement in place, but certainly one that operationally is deep and long-standing. And from our perspective, the committee, as you know, traveled to Washington, and we want to echo the sentiments that you described on the part of Secretary Kelly, which is really a very positive feedback from congressional counterparts and also DHS staff as to the nature of the border as it currently stands. And I wanted to ask you if you or the department have any statistics on the rate of incidence of withdrawal. You mentioned withdrawal from the process as one alternative to subjecting oneself to U.S. screening that one may disagree with. How many times has that actually happened? Do we have any numbers on that? Or is
it's very small. Let me see if my officials know.
Or if not, could you undertake?
We'll get the information for you. But if for example, on the issue of a search, an intrusive search. I believe, if I remember correctly, the numbers for last year show that there would not have been an incident of that kind.
Okay.
Zero in the last 12 months. Similarly, the circumstances. I'm thinking of the circumstances in which a U.S. officer might think a search is necessary, and the rules say they cannot conduct that search themselves. They have to contact someone at CBSA to do the searching. If you were to apply the new set of rules, slightly changed from what existed before, apply the new set of rules to the experience over the last 60 years or so, there would not have been one incident when there would have been a problem for a Canadian traveler. So I appreciate the concern of people who want to make this absolutely boilerplate in terms of the protection of Canadian rights and freedoms. We all want to achieve that objective, but the experience would suggest that the rate of incidents that could be considered untoward and actually invoke the provisions of the law would be very few and far between.
And placed against very large net numbers, millions of border crossings per year through people, and then billions of dollars worth of trade. And yet, Canadians may ask, how do we make sure that even for those cases where somebody is tempted to withdraw, that we have proper mechanisms and that the system and process are integral? And I wanted to ask you, it takes us slightly outside the legal ambit of this bill. I wanted to ask you if you have some comments on the nature of oversight or the issues relating to oversight of this process, because trust in government here doesn't just flow to the Canadian government, it also flows to the U.S. government as a component of the pre-clearance process. Do you have any comments on how that process could be overseen effectively?
Well, ultimately, someone with a grievance would have recourse to legal proceedings. And that's I guess the ultimate protection. But I've had I think a very good working relationship with both the previous Secretary of Homeland Security and the current Secretary of Homeland Security, and we are both determined that the experience at the border needs to be carefully monitored to determine if there are untoward circumstances that are happening. And before it would get to the point of somebody launching a legal action, and again, you look at the experience of the last 60 years, that would not have happened very much, if at all. But before you get to that kind of a situation, we need to have the kind of relationship where if Canada has a problem with the way the U.S. system is operating, or we have a problem with the way the American system is operating, we can simply communicate with each other and fix it. That's the kind of attitude that has built the kind of border that we presently enjoy, where it is the longest unmilitarized, most successful boundary relationship in the history of the world. And both sides dare not take that for granted. We both need to work at it to make sure that it continues to be safe, secure, efficient, and expeditious.
And again, the committee's experience in Washington just recently was that the interaction official to official is strong and profound and positive, and basically people are on the same page and the same vibe. I wanted to ask you if you could expand a bit on the issue of reciprocity. So the bill captures the obverse of the predominant scenario, which is pre-clearance to go into the U.S. To pre-clearance going into Canada. What are the plans there in terms of volumes and mechanisms?
I have opened that conversation with Secretary Kelly to get his suggestions or observations as to where we could start on the U.S. side. Would it be, say, in some of those large northern metropolitan areas that are pretty familiar to Canadians, Boston, New York, Chicago, Seattle, those kinds of locations? Would it be more the snowbird locations? You could think of Scottsdale or West Palm Beach or areas like that. We have to work at this together to see where it would make the most sense, where the volumes exist. There's a huge volume of Canadians that go in and out of airports like Fort Lauderdale, for example, in the middle of the winter, as there are in places like Scottsdale or Phoenix. But there's a huge commercial value in having access out of places like Chicago or New York. There's a governmental value in a relationship, say, between Reagan Airport in Washington and Ottawa. Incidentally, Reagan is one of those airports in the U.S. to which we would not have direct access if it weren't for pre-clearance, because it is a domestic airport. It does not have the international clearance facility. So if we couldn't get in there, if we could not pre-clear in Canada before you leave, you'd have to land at some other airport and then take a connection. So we're looking at the options, and they're interested in the discussion.
And there. Thank you, Minister. Mr. Spangeman. Mr. Miller, for 5 minutes.
Thank you very much. And Minister, you're always great to have you here, and thanks to staff for coming. I think the issue at hand, pre-clearance, has been covered fairly well, and I'm fairly comfortable that we're heading in the right direction there. But screening in general, Minister, is something that's come up in another avenue, and it's to do with safe third country agreement. And basically, I think everyone's aware of the illegal immigrants, legal refugees, whatever you want to call them or term them as, that are entering basically at will, and especially in Emerson, Manitoba, and in Quebec, and I'm sure in other parts, and it's probably going to get worse. But when CTV first publicized it on TV, Minister, like, my phones were inundated with people. Like, basically what it looked like was, instead of the RCMP saying, you know, look at ma'am, look at sir, you're not crossing here, I'll have to turn you back, or even direct them to a regular border crossing, if I can use that term. That never happened at all. So people can't get their heads around why security forces would be standing there and basically all but invite them in. So I guess on behalf of Canadians, and I'd like to know the answer too, why aren't they being turned around, or at minimum, Minister, directed to head, you know, to the next border crossing? And for the example of Emerson, Manitoba, I'm not sure exactly where that is from there, but I'm sure there's one not too many miles away.
Well, it's right at Emerson, just sort of a half a block west of town.
Well, then that makes it even more bizarre.
But the Canadian law on this point, Mr. Miller, is very clear. We do not have a wall that is a physical barrier to the border. When someone steps across that border in an irregular fashion, they do not get a free ticket to Canada. They are arrested. They are apprehended by the RCMP. They are fingerprinted. All their biographical and biometric information is taken. In terms of screening, that is done against the databases that we have in Canada and also databases elsewhere around the world. Is there any immigration flag? Is there any criminal flag? Is there any terrorist issue that can be raised?
Aware of that, Minister.
Yep.
And I think.
But your question was about screening. They are screened in every case.
But the problem is, Minister, that why aren't they directed to that crossing that you say is blocks away, and come in the normal way, get in line? These people are. There is no such a thing in most people's minds, and mine included, of a refugee from the United States. It's just, it's not there. You know, it's laughable to suggest it is. So why aren't these people at the very minimum told to get in the queue and what have you? It's frustrating to Canadians, and basically I think we're turning out to be the laughingstock of the world on this is how it happens like that. So, well,
I'm not sure about the laughingstock comment. You know, the situation at Emerson and at Lacole and in southern British Columbia, where there have been a few of the border crossings, the fact of the matter is this has been examined very carefully with personal visits, physical visits by the United Nations High Commission for Refugees. And they have commented that the behavior of Canadians has been exemplary, both in the application of Canadian law and in the implementation of Canada's international treaty obligations.
Well, the reason that I use the term laughable and it's frustrating to people in the queue, I have a young Asian family that are in the process. They have relatives here, but they've worked with us to basically, it's all coming up to 2 years since their application went in, and they're like going, wow, we're doing it the way we're supposed to do, and yet others are getting in ahead of us. And
getting in to be arrested. They are apprehended.
Well, let's
and then they have to make their case before the IRB, and if they cannot make a justifiable claim to be an asylum seeker, if the IRB turns them down, they are deported.
I'm going to need to end that questioning there. Just remind the committee that, and I gave Mr. Miller some leeway on this, that our topic today is Bill C-23. The minister will be back with us on estimates, and that's quite a freewheeling discussion, but I did give a little leeway on that. It's not on our topic, but I asked...
It was on topic, Mr. Chair.
I think you did your best to be on topic, I guess, but I'm just giving you a little notice that this is about pre-clearance. The minister will graciously be attending another meeting, and we have lots of time to talk to him about that. Monsieur Arsenault, on va continuer maintenant.
Merci, Monsieur. Mr. Boissonneau will keep going. Thank you very much. Thank you, Mr. Chair. Thank you, Minister. Thank you, Mr. Ward-Bolduc, Mr. Bolduc, Mr. Watkinson, Mr. Uman, Mr. McKay, or Ms. McKay, rather. I'd like to talk about Section 1, the powers of the American officers in Canada regarding pre-clearance. I'm quite aware of Section 9 of the Act, which could not be any clearer in saying that Canadian legislation applies. In Section 10.2 states that American officers cannot exercise any powers such as search, seizure, forfeiture, and so on that Canadian officers do not have. Also, an American officer must comply with all Canadian legislation, including the Canadian Charter of Rights and Freedoms. I know that all Canadian travelers going to the United States have all these rights being respected in pre-clearance in Canada. So, of course, as a lawyer, my job is to look for these little things to nitpick on. So, regarding Section 22.4, and I know perfectly well that all Canadians' rights will be respected, but in 22.4, it states regarding officers that if they have reasonable grounds that the conditions have been met, that the search can be, and the strip search can be, a strip search can be conducted, but they must be done under the following circumstances. A, that if CBSA officers refuse to conduct the search, so then 2, the officer wishing to conduct a strip search must request that a Canadian officer conduct the search, but 22.4a states that the American officer can conduct a strip search if the Canadian Customs officer refuses to do so, and there's nothing else in that section. How should we interpret this section? Or another section, if the Canadian Customs officers said, I see that there are reasonable grounds. Actually, I don't see any reasonable grounds. I don't think this person should be searched. What would happen under this section?
Mr. Arsenault, first of all, welcome to the committee. I think this is the first time we've had the opportunity to have an exchange. The one change in this section compared to the existing arrangement is that if a Canadian officer cannot be reasonably available, then the American officer can proceed with the search. 2 things about that. I have spoken with the Chief Executive Officer, the President of CBSA, to make the very strong point that Canadian officers need to make themselves available. What this legislation contemplates is that kind of collaboration and service. So if there is a problem, as I indicated earlier, you take this rule, apply it over the last 60 years, it's not likely that this problem would have arisen at all. But if it arises, then CBSA should respond and quickly to the circumstances to make sure that the spirit of the law is respected. If in some very, very unlikely circumstance the CBSA cannot respond, then the search could proceed, but according to Canadian rules, not American rules, The provisions of the charter apply, and the respect for human rights and so forth. It has to be reported on after the fact, so that the details, if necessary, can be fully examined. So we've tried to make sure that there's a very strong fence built around this provision, so that the rights of Canadians would not be affected in an undue way.
Oui, puis vous disiez dans 10 secondes.
10 seconds. All right. Well, thank you very much.
Merci beaucoup.
Thank you.
Thank you
An
very much.
excuse, man.
Sorry, but that's all the time we have. We have 1 minute left.
Go ahead.
No, I'm good.
Is what? You're giving your minute to Mr. Dubé.
Yeah.
Thank you very much. Minister, I just wanted to ask one last question on the strip search issue. I feel highly uncomfortable when we draft legislation on something that is unlikely to happen or has never happened. That's usually not how we want to proceed. So are there any concerns at all with some of the language used, especially when we think of the LGBT community and things like that, transgender Canadians who might be touched by this, especially given that American rules and regulations for an American officer might not be the same as what we demand of the CBSA?
Both border services agencies have a set of rules about how to properly respect transgender issues. Since this activity would be happening in Canada, it would be the Canadian rules that would apply, and obviously we will be vigilant to ensure that the rights of people traveling through a pre-clearance facility in Canada are properly safeguarded and respected.
And is there any openness to amending so that there'd be no instance where there would be the absence of a Canadian officer if a strip search was to occur, as is the case under the current framework? Is that change really necessary? Is it part of the agreement?
It's reflected in the agreement, yes, it is.
Thank you.
Yes.
Thank you, Minister. That time flies. Thank you for getting us off to a good start. We know officials will stay. We'll suspend for 3 or 4 minutes while we allow the other officials to join us at the table. Thank you.
Okay with all of that? Yeah.
Did you two get introduced? So excited to see our new MP here. I forgot just to welcome our substitute analysts to the committee. Both Dominic and Tanya are away today, and they arranged to have Lynn Casavant, who has been an analyst on this committee before, which is quite good for me because I remember her and she remembers me from when we were on. Maxime, we don't know, and welcome to Maxime Charon Tousignant. So thank you for being here, and it's a pretty easy gig today. Thank you also to the officials for joining us, and I don't believe there are any more presentations. You're here now for our questions, and just to remind the committee who's here, we have from the Department of Public Safety and Emergency Preparedness, the acting ADM, Joe Werrett, and from CBSA, the Vice President of Programs, as well as Deputy Executive Director and General Counsel, Martin Bolduc and Julie Watkinson, and from the Department of Transport, Tim Uman, and Department of Justice, Aaron McKee on the other end. You two are not near each other, so it was confusing me. So we are going to continue. Mr. Arsenault, you get another round now.
Merci, Monsieur le Président.
Thank you very much, Mr. Chair. Welcome again. Welcome to Mr. Uman and Ms. McKay. My questions will be perhaps a little bit more technical. I imagine that the practical way for an American officer on Canadian soil to deal with a traveler who may not want to really be strip searched, well, is there a how-to that will be made available so that, this is still in the context of an airport so that people will know what their rights are? Is there an agreement that has been put in place so that people know what to expect?
To respond to that, thank you for the question. Going back to, there's a couple of points to highlight. As Minister Goodale mentioned, officers will be trained in, U.S. officers will be trained in the procedures used by Canadian officers, in the standards, in terms of the standards for detaining people for the purposes of a search. So there is training in terms of individuals who are being requested to undertake a search. They will be offered informed of their rights in terms of rights to seek legal counsel, rights to be taken before a senior officer. So yes, training and also information provided to the traveler.
C'était principalement ma question par rapport à son droit de...
That was my main question regarding the rights to recognize that they are protected by the Charter and also that they have the right to talk to a senior officer rather. So the CBSA officer will inform the traveler of this right, if I understand correctly. So thank you. Earlier, I was fascinated in a positive way, to hear that according to the department statistics, there are no statistics showing that over the past 12 months there were any complaints regarding this. Is that right? There were no complaints regarding strip searches?
The specific figure that Minister Goodell mentioned was we had asked our colleagues in U.S. Customs and Border Protection to look at their statistics for the last year and CBSA, and there were no cases in the past year where U.S. Customs and Border Protection had asked CBSA to undertake a strip search. And, of course, that's the only possible venue right now is for CBSA to undertake the search.
OK. Puis est-ce que... Oh, intéressant, vraiment intéressant.
That's very interesting. And that's for the past 12 months.
12
yes,
months.
that's correct.
Yeah. Je sais que souvent, il y a des...
I know that there are often travelers going overseas or to another country. The U.S. isn't overseas, but there are travelers who don't speak the same language. Will there be any requirement that all passengers can be provided with service in both official languages since we're still on Canadian soil? Is that provided for?
The same provisions that apply now in pre-clearance, there are no specific provisions around that in terms of U.S. officers. The same provisions that apply currently in pre-clearance apply to the U.S. officers. So there is no requirement for them to provide services in a variety of languages. Martin, I don't know if you can speak to that in terms of further detail on some of the practices, though.
Mais c'est déjà en place où...
That's already in place. That is, across many airports in Canada, when U.S. border officers handle passengers who are unilingual, francophone, or don't really speak English, we already have practices in place. We have no knowledge of any incidents related to language. And I would tell you that USCBP, in selecting their officers, will give more points to officers who have French language abilities. So I have met American officers posted to Canada who were able to speak French. How much time do I have left, Mr. Chair?
Je vais partager, je vais prendre 30 secondes.
I'll take 30 seconds and give the rest of my time to my colleague, Mr. Picard. But in the practical sense, as soon as somebody enters the pre-clearance area, will they have access to something in both official languages saying, these are your rights? Yes, all of the signage in the American pre-clearance area is in both official languages, but that's not an obligation for, American Border Services officers to be bilingual. Yes, I'll give my time to Mr. Picard. Thank you very much. When somebody goes to the pre-clearance area, they have the right or the privilege of removing themselves or withdrawing themselves from the area and going home. Now, the concern is that the American border officer to question somebody who would want to withdraw. I imagine this person is still in Canada. What are their rights? And how is their privacy going to be respected in terms of the intelligence they might provide or that will be collected on them? And how can this information be set aside, or rather kept? I'll let my colleague answer that, but I'll provide a little bit of context. Today, somebody going to a Canadian airport to access an American flight will, first of all, go to the airline's counter and provide their travel documents. They will be swiped. These documents will be swiped. So their biographical data will be captured by the airline and will be sent to American Customs. So they will have the information on the passengers. After that, they will present themselves to the security area, and after that, the third step will be to meet the American Border Services agent. So you'll go through a number of steps before reaching an American border officer, but perhaps my colleague Jill would want to answer the rest of your question.
Just to elaborate on that, I think as Minister Goodell stated, there's limited authorities in terms of questioning a traveler on withdrawal. It's, again, to ascertain their identity and their reasons for withdrawing. So the expectation is it would be a limited set of questioning. Those questions would be responded to, and in most cases, the traveler would move on. To add to what Martin said, most of us can picture the airline context where it's quite quite controlled, and where people have already provided a great deal of information before they might decide to withdraw. But the bill was also, the agreement and the bill were designed to deal with the other modes of travel as well, where you're dealing with a different kind of context if there was pre-clearance at a land border, for example. So again, it's to recognize those different situations and to ensure that fairly minimal set of information can be obtained in order to alleviate concerns around probing the border for weaknesses.
Thank you. Mr. Clement for 7 minutes.
Thank you. Just want to talk about cargo for a second. Obviously, this is an important aspect of cross-border trade, and the bill is, as I understand it, not focused on that. There was the prior Conservative government established a pilot project for truck cargo pre-clearance at the Pacific Highway port of entry. So I'm just wondering if there are any plans to move forward with a broader rollout of that kind of initiative.
As you mentioned, there was a cargo pre-clearance pilot under the Beyond the Border Agreement where there was cargo pre-clearance. The initial testing phase was done in BC and then also second phase in Ontario. At this point, there are no specific sites identified for cargo pre-clearance. We're beginning to explore within Canada and in discussions with U.S. colleagues our objectives for cargo pre-clearance, what some of the legal or procedural requirements would be, and also specific sites where cargo pre-clearance may make sense. I mean, ultimately, as with pre-clearance generally, it's driven by the economics, where it makes sense economically and where it's feasible in terms of border operations. So the short answer is no specific sites yet identified.
So what's the next step on that, do you think? Identifying another site?
The President Prime Minister committed last year to explore the terms and conditions for cargo pre-clearance and to explore possible pilots. So that's what we're looking at right now with the U.S.
So just get back to the travelers then for a second as well then. My understanding is that basically about 12 million passengers per year were pre-screened. Do we have any projections of what that number would be under the new legislation?
That's correct. It is about 12 million per year. I don't believe we have any projections. I'll just turn to my colleague from Transport to double check on that.
So pre-clearance has been, the number of passengers pre-cleared has been growing basically at the same rate as passengers headed to the U.S. That follows economic changes. The value of the dollar is a big effect. So it tends to be quite responsive to economic factors such as that. But year on year, there has been steady growth in passengers.
Like at 2% or 3% or?
I can't give you an exact number, but follow up.
Maybe get that to me if you have a chance.
Yes.
Now, another aspect of this is just the cost for Canadians of air travel because of all surcharges and airports like Pearson with their surcharges as well. And it actually drives Canadians, at least those close enough to the border, to use U.S. airports like Buffalo as a common one that happens in the GTA. So I'm just wondering, with this bill, do you have any projections on whether it'll reduce the cost for air travel for the average traveler?
We don't have specific projections on that. I guess 2 points to make. In terms of the agreement, the agreement does provide for cost recovery for new pre-clearance operations. So the 8 existing airports are protected from cost recovery unless there's some kind of an extraordinary request for special services outside of the normal operating hours of pre-clearance operations. In terms of new sites, there are provisions for cost recovery. Similarly, if CBSA were to go to the U.S. and do pre-clearance, there would be cost recovery for operations. Those discussions are happening now between, those are site-specific in terms of discussions between the U.S. and the individual pre-clearance sites for pre-clearance in Canada. But one of the one of the pieces of work that the Canadian government is doing is to work closely with the U.S. to ensure that we understand the framework for cost recovery that they're applying and to keep costs as low as possible for the traveler.
Have you done any studies, has the government of Canada done any studies on costs to Canadians? My understanding is that we rank 124th in the world in terms of cost competitiveness at the cost of air travel. So have you done any independent studies on that, or is that something that your department is seized with?
So So the government is concerned about the costs of travel, air travelers in particular. That isn't specifically related to preclearance, though. That's pretty much a separate issue.
If we're doing cost recovery, look, I'm all for preclearance, believe me, but I'm also concerned about being cost competitive when it comes to air travel for Canadians. So it might be a topic that you might want to consider. Thank you.
I might just mention that that did come up in Washington on our trip. I've made notes on it about American officials suggesting that they've already been asked about expanded border services on a cost recovery basis that would cost Canadian travelers more because that would be passed on. So that was raised on our trip, and I could see a little bit of the light going off in their eyes about more cost recovery. If they were to provide those same services on their own soil in a non-pre-clearance operation, they would be doing it in those airports. Now, I could argue that you're going to get charged by an airport in either end of your destination. I think there's some work, though, that needs to be done on that.
I agree with what you just said. The point is, we're already non-competitive. We're 124th in the world in terms of cost competitiveness. So this has a disproportionate impact on Canadian travelers because we're so non-competitive right now.
It is. Go ahead.
That certainly is, again, factoring into the discussions we're having with the U.S. to make sure that a fair and clear cost recovery model is applied, but it also factors into the decisions finally about whether a site will undertake pre-clearance. It has to be economically viable for the operator of the facility, for the air carriers that the cost would be passed along to, and ultimately for the passengers. So that will certainly factor into whether pre-clearance operations would start in a particular site.
Thank you.
Okay, Mr. Dubé.
Oui, merci, Monsieur le Président.
Mr. Dubé, thank you, Mr. Chair. I was wondering whether anybody could tell us how many regulatory changes will be made through the agreement that are not in the Act.
Yet another flood.
If you don't want to break it, Rob, just ask for another picture. Sorry.
I can't speak to specifically how many regulatory changes will be required, but there will be regulatory changes required in relation to both Parts 1 and Part 2 of the Act. So Part 1 is U.S. operating preclearance in Canada. Part 2 is Canada operating preclearance in the U.S. And some of the examples of the types of regulations that would be required under the Act would be regulations to authorize persons or the categories of persons who would have access to preclearance areas. So we will need regulations for that in Canada, and to establish conditions for that access. Regulations to authorize how detained goods would be disposed of. And then regulations will be created or amended to permit CBSA to administer its various acts and regulations on an extraterritorial basis. And there's a long, long list of acts that CBSA administers. I don't know, Martin, if you want to add anything to that. So that's quite an extensive exercise.
I believe that the analysis conducted by my department showed that there are about 200 regulations that would be impacted by having CBSA operate on American soil. Now, without wanting to add to the burden of all the work that has to be done, I think it's important for us to really understand the changes that are going to be made by the bill, to have a list of those regulations. Could we get a commitment to get a list of those regulations that will be changed or impacted?
We are still exploring that right now. I think we could provide you with some general outline of the types of areas where regulations would be required.
Yes, please. L'autre question que j'avais, c'est concernant le...
Thank you. My other question is regarding a cost, but a different angle from my colleague's question. We saw, well, the people of Quebec City are quite pleased, but about the announcement. But they were wondering who was going to pay the bill for this. The airport was saying that airport authorities were saying that they were disappointed to see that in Montreal's case, the bills had been paid by someone else, and that at the Quebec City Airport, they would have to pay. What will be the impact on the facilities and then possibly on the consumers?
As I mentioned, the current pre-clearance operations are protected from cost recovery. That was one of the elements in the negotiations over a number of years. The U.S. is pursuing global pre-clearance, and they're applying cost recovery in all their operations. In fact, they're obligated to by Congress. So cost recovery is being applied to any of the new sites that are under discussion. And ultimately, it will be, again, the decision of the airport authority whether it makes economic sense for them to pursue pre-clearance and to explore for themselves what kind of arrangements they may need to make in order to ensure that those costs can be covered.
Maybe this question is better suited for Transport Canada, but is there any study being done of whether or not the federal government will be at all involved in helping alleviate those costs for some of the airports that maybe think it's disappointing that Montreal and Toronto didn't have to pay them, but they're sort of getting tapped on in that sense?
So just to break it down, so there are two fundamental kinds of costs. There's the infrastructure costs, like that's for building equipment and counters and that kind of stuff. All facilities have in the past paid for those, and all facilities in the future will continue to have to pay for those. So those have always been facilities-based. Where the new agreement makes a distinction is between the existing airports that have had pre-clearance operations and the new operations. So there, in that case, it's for the new facilities. They also have to cost recover the cost of the U.S. CBP officers' time. So that's the difference, right? Certainly, what's open to any facility that has an interest is to apply through the normal means to either federal or provincial authorities for various programs to pay for, the infrastructure costs in particular. Normally, the way these things proceed is that the operating costs are covered through, through either putting it directly on passenger tickets to a certain extent, or maybe recuperating it from other fees, like parking fees, for instance. So operating costs are normally covered by facilities.
Okay, merci. L'autre question, je vais revenir. M. Arsenault a parlé des langues officielles.
Thank you. I want to come back to this issue of official languages. Of course, when we travel to the United States, we know that we'll be speaking a different language. But a significant issue is regarding those who withdraw from the pre-clearance area. They will be asked some questions. So the level of French to be able to put people at ease in this kind of delicate situation is quite significant, especially since these people may already be leaving the pre-clearance area because they were treated inappropriately, in their opinion. It's not the same thing to be interrogated by border officers than going to the beach in Florida or something like that. Are there any measures in place to ensure that Canadians who wish to express themselves in French would be put at ease in this kind of case where they leave the pre-clearance area?
As Martin mentioned earlier, signage would be in both official languages, so travelers would be able to understand what their rights and obligations are in both official languages. That takes us back to one of those factors in terms of the unreasonable delay and the discussion around that. There are a number of factors that are taken into consideration in making sure that the traveler is not detained for an unreasonable length of time, and one of them would be language barriers. So I think that would be something, again, that CBP would need to look at in the withdrawal context. As Martin said, one of the, as they look at the officers that they bring to Canada, they do look at language, and so that's something that they'll need to look at in terms of ensuring capacity.
Est-ce que c'est possible?
Would it be possible to include this element in the bill explicitly as a reason for time frame becoming unreasonable without going against the agreement?
That's certainly something we could look at in terms of factors that could be included.
Thank you. Ms. Damoff.
Thank you very much for being here. And as was mentioned, we were in Washington last week, and it was expressed to us how anxious they are that we deal with this legislation. Our process is much different than the American process in terms of passing legislation, and the whole committee process and the way things work here aren't completely understood there. I did have a question when we were talking about the cost of pre-clearance, because it was mentioned to us when we were there that Pearson has already requested additional pre-clearance. Would that be on a cost recovery basis, the new officers at Pearson, or would that be covered into the old agreement?
It would depend on the nature of the services being requested, and it's case by case in terms of those kinds of requests. They'd have to look if it's outside of normal pre-clearance operating hours, if it's to reflect the growth in travelers that we spoke about earlier. So it really does depend on the type of increase that's being requested.
Yeah, and the way they spoke, it was to deal with the growth in travelers, that they wanted to expand the size of the pre-clearance that they had.
So I can't give you a precise answer to that because it does depend on the details of what's being requested, and ultimately will be discussion with U.S. Customs and Border Protection, which is something we'll be monitoring closely, but it's ultimately a discussion between them and between Pearson.
Okay. Going back to the education part of it, you've indicated that the Americans will receive training on our charter and legislation. Will that be, is that a one-time training, or is it ongoing training that happens with these officials? I mean, do they arrive on Canadian soil, get trained, and then away they go for however many years they're working here, or is there a program to provide ongoing training to them?
The initial training would be provided by CBSA, but also they would be receiving training from CBP. Any officer that gets a posting abroad gets training from CBP as to the country they're going to, and so on and so forth. If there were to be any significant changes to the operating environment, yeah, for sure, we would provide those updates in a regular fashion to U.S. officers.
Okay, so we don't provide ongoing training on. I mean, it's a lot to absorb when you're starting a new position, right? And understanding the nuances of our charter versus their.
Agreed, and that's probably the most significant differences between U.S. CBP and CBSA is the legislative and the legal framework. As for I'd say the normal procedure, there's a lot of similarities. So, but it's something that we will look into, and if needed,
I'm not
for sure.
worried so much about the procedure part of it as I am just making sure that they have knowledge of Canadian law and the charter specifically. So, yeah, and I don't think that's something that's legislated anyway. I think it would be something that you would be looking at.
You make a good point, and something that we can include in.
And that kind of leads me to my next question, though, is how much this is being governed by an agreement that's already been signed. So how much leeway do we have in amending this bill that's before us right now?
That's a somewhat difficult question to answer. It would really depend on the nature of the amendment. So that's simply the answer, that there are certain things that are clearly spelled out in the agreement, and so it would depend on the nature of the amendment proposed, whether it was consistent with the agreement or not.
Okay, so as we work through this, I guess that would be a question I'd have for the clerk later as to how the process will work to make sure it, or how will we know what falls within the agreement and what doesn't then? Okay, I want to go back to the issue of having bilingual officers. And we can't make the assumption that everyone who arrives at the airport is bilingual. They could speak only French. I suspect that already happens, except that there's going to be different rules in force now. What happens to that person who arrives at a pre-clearance destination speaking only French and they encounter an English-only American Border Services person?
I cannot speak to the specific of how a U.S. officer deals with that. I could explain how a CBS officer would deal with that. In interaction with a traveler, you want to make sure that there's an understanding. So in those cases where we have somebody that presents themselves in front of us who cannot speak either official languages, then we have translators that are available and have the ability to reach out to those people, making sure that that there is a clear understanding.
But I'm talking specifically about someone who does speak one of our official languages and has a U.S. Officer who doesn't speak French. So they don't have the right to withdraw any longer. And it just seems like it could be challenging, well, it would be challenging communicating, but it could easily lead to a misunderstanding when there's a lack of being able to communicate in the same language. Is there any ability to bring in a Canadian officer who does speak French to assist with that?
I'm sure that a U.S. officer would make sure that there is somebody that can translate that, and that the traveler has an understanding of what's happening and line of questioning. So, yeah, I think it's something that we can look into discussion with U.S. authorities.
Certainly, I only have about 30 seconds left, so I'm just going to say I know recently I flew from Billy Bishop to New York, and of course they don't have pre-clearance there, and it had been a long time since I'd actually flown, having to go through customs on U.S. soil, and of course I'm in the same line as people who were coming from the Philippines and many other countries, and I think it was an extended delay that we had in New York going through customs compared to what we go through at Pearson. So I'll leave it at that. That's my 7 minutes.
Good. Thank you. Ms. Watts.
Thank you.
5 minutes.
Great, thank you. And I've just got two things I would like to address. And I have both the Peace Arch border crossing and the Douglas border crossing in my riding. And this relates to the Beyond Border pilot project. What I heard was that of course that project was underway and it came to closure. Now you're looking for other pilot projects. So what were the outcomes of that? And why are you looking at other pilots when you've already done a pilot and you already have the information I'm assuming that you would require?
The purpose of those pilots was more to test the concept of cargo pre-clearance, and the concept it was a pre-inspection pilot where we were doing pre-inspection in Canada with still the potential need to go to secondary inspection in the U.S. So it was those sites were chosen because they have a significant amount of traffic and for other factors like that. But it wasn't necessarily that's where we would end up having pre-clearance. It was really to test the concept and how it operated. And so each element of those pilots were testing different aspects of that.
Right. Yeah, because I know that, at the Douglas border, the lineups are with the trucks are just horrendous, and it's been very problematic on that side of the border. So, and I understood as well, the minister was saying that it would take some time to get all of those things worked out. So, will you actively pursue pre-clearance of cargo?
Yes, as the minister mentioned, both the Prime Minister and President have committed to pursuing cargo pre-clearance. So the minister also mentioned there are a number of complexities to work out. We have to look at where cargo pre-clearance ultimately makes sense, but that's something that both countries have committed to doing.
Okay, and is that work begun?
Yes, we've been in discussions with the U.S. for a number of months in terms of what our objectives are in terms of cargo pre-clearance, both countries looking at what kind of legal authorities or other authorities they would require, and also to talk about potential pilots, potential sites for cargo pre-clearance.
Excellent. Perfect. Yeah, I think we need to go down that road for sure. My next thing is, and with CBSA, and I've always had a good working relationship, and I was very pleased to hear when we were all in Washington how highly your counterparts speak of the relationship and the working relationship. Absolutely. So I really wanted to relay that to you because we heard that on numerous occasions, and it was very, very clear that they really appreciated the work. My I'm going to try not to get too far off a topic, but one of the things that your U.S. counterparts did have some concerns about were the removal of the visas for Mexico. And so they've implemented certain measures to try and mitigate some of the serious issues that will unfold from that. Are you involved in that, or are you removed from that, or how does that working?
I can't speak to the specific measures they would have put in place. What I can tell you is that we've had discussion with the U.S. They share their concern, and trying to reassure them is the fact that first of all, people need to get an ETA to fly to Canada. Our officers are trained to discover non-genuine visitors, which occurs daily. And those people either withdraw their request to enter Canada or sent back. So, and when I ask colleagues at Customs Border Protection of how many instances have they encountered Mexican national who would have flown to Canada and make its way to the U.S. in between border crossings or at a port of entry, the number was very, very small. So that reassured me that the measures we have in place are working as they should be, and that our officers are doing a good job.
Mm-hmm. Well, and I did appreciate the fact that they don't want these people coming back into the U.S. The only thing is that they're probably most of them want to remain in Canada. So I think that's, and that's why I'm asking the questions. Just like I said, the working relationship is really good, and if those working relationships will continue on that front, because like I said, it was identified.
Thank you for the feedback, and as you said, it's a solid relationship. So when there are issues, nobody's shy in picking up the phone and calling on the other side to seek advice or to work collaboratively.
Thank you.
Perfect.
Mr. Picard.
Je vais partager mon temps avec.
Thank you. I'll be sharing my time with Mr. Arsenault. First question regarding clearance. Usually that means additional costs for companies in terms of time and resources. NAFTA had the CDPAT program, for example. There were additional procedures that were imposed on transport businesses that, of course, increase the costs per delivery, and that goes against the economic goals of the program. Will the cargo pre-clearance require new programs and new measures, or will there be other measures that we'll have to take to meet the obligations under this agreement?
On ne prévoit pas.
We do not think there will be new programs introduced. That's not what we are planning for. But as you know, with Beyond the Borders, we tried to ensure our programs work together so that both countries would recognize the advantages provided to businesses this way. So the objective is to continue along the same line, and we do not want to increase costs for businesses or add more requirements that would do the opposite of simplifying the process. Mr. Chair, I'll give my time to Mr. Arsenault. Yes, I'm reassured when reading Section 29. I'm still in Part 1 of the legislation, of the bill, rather. Perhaps my question is more for Ms. Verret or Ms. Watkinson. I always want to see that we can, that travelers can withdraw from the pre-clearance area if all is going well. Now, looking at paragraph 14.
Says, if a pre-clearance officer has reasonable grounds to believe that person has committed an offense under an act of parliament, the officer may, in a pre-clearance area or pre-clearance perimeter, detain the person. Et lorsqu'on lit l'équivalent en français, on dit que...
Now, looking at that in the French, it says that the officer may detain a person if there's an infraction of a federal piece of legislation, but that they could be referring to the U.S. legislation. U.S. legislation is federal as well. I'm sure it's about translation or something like that, but I wanted to share my concerns regarding that word.
Is that only if there's suspicion of an offense, Canadian offense, would there be the ability to detain?
Donc, on devrait lire 14.1 comme étant une infraction à une loi.
So we should be reading 14.1 as going against a Canadian law. That's right. Or an offense, because the concern is that anybody who has committed something that could be construed as an offense against federal American law could be detained. So that could be how it could be read. That could be the damage from this paragraph. But you are telling me that the intent is really a Canadian offense.
Merci. C'était ça ma question.
Thank you. That was my question. That was it? Great. All right.
Thanks very much, and thanks, Ms. Oh my gosh, I can't see the name, Ms. McKee, and Mr. Uman for joining us. I just wanted to carry on a little bit. I've got international waters that my riding butts up to, but I don't have any major bridge crossings. But I find it very interesting, Ms. Watt's questions, and I think there was some other ones in regards to some of these trial projects in order to speed up the process of goods that are crossing. And, you know, with jobs in the economy hinging big time on that, I'm still not clear why with those draft projects or trial projects at the head, why we're not basically implementing it full time or whatever. So could somebody enlarge a little bit more on that?
Sure. A couple of different reasons. As I said, part of the reason that we do pilot projects was to test the concept to see how it worked. The specific project that we did in Ontario, there was a lot of valuable learnings from that, but also some learnings that some of the benefits in terms of efficiencies can also be achieved through technology. So it's important to look at what we can do through existing technology, what might require infrastructure changes that are fairly complicated, because you can speed traffic up moving to a bridge through pre-clearance, but ultimately if the infrastructure at that bridge is limited, there's a limited amount you can do in terms of moving traffic quickly. But the other point is that we don't now have the authorities to implement cargo pre-clearance. Under the current act, we don't have the authorities. Those were pilot projects that were done. So again, we require the legislation in order to move forward with cargo preclearance.
Okay, so are you getting any inclination in any way, Ms. Ware, is the government going to implement that legislation?
Well, it would require passage of Bill C-23 on the Canadian side, and us again looking at the different opportunities for cargo preclearance.
Okay, so it will be fully covered under 23 if...
Yes, the Canadian legislation gives us the legislative basis that we need to do cargo preclearance. On the U.S. side, they've continued to say that they may need some other provisions, whether it's legislative or other kinds of agreements. And just as we have with all of the individual preclearance sites, we have the framework legislation, but then we have individual agreements to provide for the operations of preclearance at those sites. So again, there may be some specific operational types of agreements we would need in order to run cargo preclearance at different locations.
Okay, you also mentioned technology, and of course we have to keep up with that. Is the new Gordie Howe Bridge that is going to be here eventually, I take it by your comments then that any new technology that can be implemented while that's being done will be done at the time of construction? Is that a fair
I can't speak to the specifics of the new bridge. I don't know, Tom, if you could speak to that.
Just to say that at the Gordie Howe Bridge, the planning right now that's going forward is for the customs to be at the typical places, so classic clearance as opposed to pre-clearance.
Okay, but not both.
So that's not to say that in the future you couldn't do cargo preclearance, but the idea is right now the way it's being set up is the U.S. Customs Plaza is going to be on the Canadian side, the Canadian Customs Plaza is going to be on the U.S. side, which is your standard setup for classic clearance.
Is there any hesitation from the American side on this? Like, are they basically good with it, or do they have any specific concerns that you haven't mentioned? Or?
With pre-clearance generally?
Yeah.
They're very enthusiastic about pre-clearance. As I mentioned, they have a global pre-clearance strategy. They're rolling out pre-clearance. They have it in a number of other countries now. I think, if I'm not mistaken, 7
So
or 8
that
other
shouldn't be
countries.
an issue.
So they're very keen on pre-clearance, and they see it as very important for their security to
Okay.
push at the border.
Thank you. That's all I have, Mr. Chairman.
Mr. Spiegelman. And Mr. Dubé, you'll get another little round.
I will join the chorus for a moment on cargo pre-clearance and ask you, well, first of all, to say that, especially in light of the current currency environment, I think it's crucial that we don't lose our competitive advantage vis-a-vis exports to the U.S. You're not the department that's monitoring the economics most closely. There's others. There's colleagues of yours that do that. But is it your sense that it's an equally hard push from the corporate sector in the U.S. and Canada, or are the Canadian voices louder in terms of the need or the interest in making this happen?
Don't really have a sense of that at this point because we're still in fairly early days. We've certainly had some interest expressed to us, but I don't have a sense that it's stronger on either side.
Okay.
No.
And from your perspective, are you aware of or in possession of any economic studies that have looked at this problem and sort of taken a view of the net opportunity that exists for us? Appreciating the fact that there are multiple bottlenecks, and even if we pre-clear and the trucks get stuck at the bridge logistically, that's an issue. But just from the pre-clearance side, what the economic opportunity would be if we had it in place in all the different areas that would lend themselves to that?
We've looked generally at the economic benefits of pre-clearance writ large. I don't know that we've drilled down into specifics of cargo pre-clearance in certain sites, but that, of course, would be one of that we need to make a business case for cargo pre-clearance in different facilities or different locations, so that would be required. I don't know if there's anything you want to add.
Just there was a question asked earlier about why aren't we pushing ahead with cargo pre-clearance now? And besides the fact that the agreement isn't in force yet, the other issue is, of course, we've got to learn how to do cargo pre-clearance. We don't have the decades of experience that we have with traveler pre-clearance. We got to learn, like, how to secure loads. We've got to learn how to make sure that you've done the necessary checks, but you haven't gone overboard. So hence the importance of continuing to do pilots and identifying new cargo pilots that build on the Pacific Highway and the Peace Bridge pilots that were done before. We've still got things to work out and to figure out. I think once we've been through a round of those cargo pre-clearance pilots, we'll have a much better idea of, one, the economic opportunity, and two, what are the actual costs of establishing cargo pre-clearance.
Thank you for that. I'm going to switch gears and take it to Article 24. I have a question on X-rays. Under what circumstances would an X-ray search be the only alternative to effectively search the traveler? And I'm thinking particularly with respect to the backdrop of my question to vulnerable segments of our population, including pregnant women and potentially people who are compromised because of existing medical conditions. How often do we actually do X-rays, and are they required? Are there technologies that are really going to minimize, if not eliminate, cases where we have to resort to X-rays?
I think I'll turn to Martin, who can speak to the actual details of when those kinds of searches are required in the CBSA context, which would be similar, I think, to the CBP context. But to be clear, in the legislation, those searches cannot be undertaken by an officer. They have to be undertaken by X-ray technicians on the consent of a physician. So
I appreciate that.
Requires physician's consent.
The traveler has to consent as well.
As well, yes.
And presumably the alternative to consent is to refusing consent is not to be able to travel. Or are there backstops? Are there alternatives to X-rays?
So an officer would have to believe that you have contraband inside of you. Yep. So if I have contraband inside of me, I would not give you my agreement for an X-ray. And if I have nothing, then I would give you that. So it does not happen very, very, very often. I could provide the committee statistic if we compile those. I would have to confirm, but it's not something that's very often.
If you have a pregnant female passenger with a suspicion of contraband, turns out that there is no contraband in the hypothetical, and she refuses, is the only alternative at this point for her to withdraw from the pre-clearance area?
she would, or then it's a very specific case. I would have to think if we are to conduct that search. I've seen instances where we detain people up to 24 hours.
Okay.
To do a bowel movement.
So that's a third option, yeah. Okay.
Could be, yes.
Okay.
And then again, those cases are very specific.
Right.
Sorry about that. It's just before dinner, but
Okay.
it is the reality.
Yeah. Let's get a box of
That's our
you're good to
time.
go.
Mr. Dubé, you do have 3 minutes if you would like.
Oui, merci, Monsieur le Président. J'avais deux.
Thank you, Mr. Chair. I have two last questions. The first was regarding the training. Who gives it? We talked about it earlier. The minister, when he was here, said that CBSA and others. Could you tell us who the others will be? Is there somebody else who will be involved? Is that formalized, of course, in any kind of agreement? We don't have a list. But others could include those in charge of security in an airport, at a particular airport, the colleagues from the various intelligence agencies in Canada, for example, CSIS. That's something we could look at. And there's also, as I mentioned, CBP, the U.S. CBP, who do provide training to their officers who are posted here. Is that codified anywhere, if you allow me the question? No, I don't have a specific list, no.
Almost ad hoc basis, if there's no formal list or anything, like how does it, if it's not codified somewhere, I'm not clear how that works.
Je peux vous dire que CBSA va donner la force.
I can tell you that CBSA will be providing the training. Now, to your question as to who the others are, there's no exhaustive list of other organizations that may be called upon to provide training. It's on an as-needed basis, yes, but it's something we could look at. My last question is regarding the location of pre-clearance areas in the U.S., so Canadian pre-clearance areas. We were talking about our trip to the U.S. I was surprised to see that it wasn't really part of the discussions when we asked them. Are there any negotiations underway? I asked the minister a question, and I heard that it was something that would be established a little bit later. But Mr. Bolduc, for you and your colleagues, it's something that may be of interest. Who's going to go where? So I don't know if these are discussions that are currently underway, if we are all going to know what the locations of these areas will be in the U.S.
That's something I think, Martin, you may want to speak to that as well, but that's part of the work that lies before us in terms of establishing where preclearance might make sense in the U.S. Again, it's economically driven. The U.S. has a process where they put out a call for preclearance applications, and it's the airport authorities who apply. So similarly, it needs to make, for Canada to operate preclearance in the U.S., it would need to make sense for those airport authorities and for CBSA, because of course while there's cost recovery, there are also costs incurred at going to the U.S. and operating preclearance.
Non, ces discussions-là font partie du comité de travail.
And those discussions are being worked out and held at the working group, as our colleagues mentioned. Now, regarding the volume of passengers coming into Canada from the U.S., where we'll have the most return on our investment. And also, do the airport authorities have the room they need to build a preclearance area for us? These are all factors we'll be looking at. In terms of our American colleagues, they're very open. Even during our discussions with us, that they were ready to share with us all the call for tenders process, in details every year. They hold a process like that, and the airports apply. That's how they operate now. And even then, I think it's something we can still use. The U.S. has had preclearance areas for 60 years in countries outside their own, so we can definitely draw on their experience and their expertise. Thank you. Thank you very much to all the officials and our witnesses here today.
Not only today, but for bringing this bill along to this point, and we will continue to do our work over a pretty compressed time period to get it back to the House as quickly as we can and as appropriately as we can. So thank you, everyone, and we will see you on Wednesday.
Thank you.